Right, we talked a while ago about equal protection in general and the tests and how they work. But all of the, well, most of the examples that I mentioned and most of the cases that you see historically are cases in which the group defined by the characteristic, the group that's bringing the litigation, is disadvantaged by the classification. So minority groups oppressed by some particular restriction, or a group defined on the basis of gender, denied the opportunity to do something based on their gender, and so bring a lawsuit to protest that that's an equal protection violation. What happens when the group defined by the relevant characteristic is actually supposed to benefit from the classification? What happens when government, either the federal government or a state government or a local government, divides benefits eligibility along a line that is suspect in a negative scenario? So, for instance, what happens if a group defined by race is given particular benefits that other groups aren't? Scholarships for African American kids, or preferences in hiring for groups defined by national origin, either to provide role models for members of the group, to allow members of the group to break into upper management in areas where they've been historically underrepresented. In other words, to provide some form of more proportional representation than has resulted from historical practices, in part probably because the group that's underrepresented or that's been suffering under the current division has historically been denied opportunities. So the group may be poorer or less well educated or something like that, and those factors play into the absence of people in particular positions. So we're going to adjust the rules a little bit to equalize representation, and then from now on, after we get that sort of laid out more fairly, we can move into a juster era. These sorts of efforts historically have gone by the name of affirmative action, where Congress or the state governments or municipal governments are going to use their power to legislate benefits for historically oppressed groups, groups defined by characteristics that the court would find suspect in the case of legislation intended to hurt those groups. And so we could talk about race. If a state passed a bill saying, or an act saying you can't own property if you're African American, well, it's easy. Race-based classification, strict scrutiny. Is it necessary to a compelling end? Answer, probably not. So that statute's unconstitutional under equal protection. But what about we don't have enough police officers who are black, so we're going to set aside X percent of police officer positions for black applicants so that we can have a fair representation. How do you analyze that under the Constitution? And this was a problem for the court. Now, it could be, and the argument was initially made, you should analyze it just as you would if the legislation were designed to hurt that group. But a number of the justices on the court said, well, that doesn't make any sense. You know, and let's talk about race. You know, the Equal Protection Clause was passed to safeguard the rights of newly freed African American slaves. Why shouldn't it be easy for Congress to pass legislation specifically designed to help that group of people, to help them integrate into the mainstream if other factors are keeping them from fully participating, other than legal barriers of poverty, barriers of education, barriers of private racial discrimination. So what we had was a long period of time, and this is this passage of affirmative action legislation is a fairly modern phenomenon, but we had a period of time where the court wasn't quite sure what to do. Now, those people who thought that these sorts of efforts ought to be easier to do than not favored, as we know as equal protection analysts now, a lower standard of review. So if I'm a legislature and I'm going to pass a statute that hurts black Americans, that ought to be strict scrutiny. I can only do that if that classification is necessary to a compelling end. But if I'm going to pass a statute that's going to help African Americans, well, that ought to be rational basis. I can do if it's rationally related to a legitimate end. That means it's easier it's easier for me, the government, to defend doing it. And a number of justices felt that that ought to be the level of review. The first case, major Supreme Court case that came up on this topic was the Bakke case. Alan Bakke, white medical school applicant, is 1978, applies, doesn't get in. He believes his credentials are better than some African American applicants who were admitted, his test scores and educational background, et cetera. So he sues and says this is a violation of the Equal Protection Clause, and he argues that the level of review ought to be strict scrutiny. Bakke wins his case, but not because the Supreme Court adopts strict scrutiny as the level of review. In fact, the court went all over the place. Well, it isn't a constitutional claim, it's a statutory claim. Or it is because there's a federal statute that bars discrimination on the basis of race. So he wins under the statute, and we don't have to decide the constitutional issue. Or other justices, well, no, it's a lower level of review. This is affirmative action legislation. It ought to be easy for the state government to pass it. So there's confusion. There's consensus on the judgment, or a majority in favor of the judgment, which is Bakke wins, but there's absolutely no majority on the rationale. And that was the status quo for several decades. Certain justices on the court wanted to establish two-tiered equal protection analysis. So affirmative action legislation got easy review, and adverse discriminatory legislation got really hard review, but they could never get a majority to support that breakdown. Other justices didn't see why there was any sort of a difference. And one of the leaders of that group, intellectual leaders, turned out to be Justice O'Connor, and interestingly, the other major proponent was Justice Thomas. So a female justice and an African American justice. Justice O'Connor, most importantly, I think, in an earlier case, expressed her view on the matter in a decision that she wrote in a case called Mississippi University for Women versus Hogan. And in that decision, what she was confronting was, what the court was confronting was a Mississippi school that was a nursing school, and they didn't want men to attend. They had a discriminatory policy in favor of the admission of women. And a guy applied, and he didn't get in because he was male, and he wanted to attend nursing school. And what the school's defense was, well, this is affirmative action legislation. It ought to be subject, it's to help women, and it ought to be subject to a lower standard of review. And what Justice O'Connor said, there was no consensus on the level of review. The discriminatory policy was invalidated. But what Justice O'Connor said was, you know, I'm not seeing this as really beneficial to women. Seems to me what the Mississippi University for Women is doing by confining its nursing program to women is reinforcing the stereotype that only women are nurses, or that nursing is one of the permissible career paths for women, but not for men. And I'm not really constitutionally comfortable with that. So that got invalidated. Now, that is what set the trajectory for what became in the 1990s the modern rule. And Justice Thomas, I mentioned, expressed some of the same feelings about affirmative action legislation based on race, which is, I'm not sure this is really helping me. This seems to me to be somewhat patronizing and reinforcing stereotypes that I couldn't have made it on my own, that I need this support. Now, that view hadn't been a majority view prior to the 1990s, but in a couple decisions in the 1990s, a majority of the court was persuaded that that's what the law ought to be. The two seminal cases from the 90s were the Crossan case, Crossan versus City of Richmond, and the Adirond case. I said 90s, Crossan's 1989, Adirond is 1995. And what the court did in those two cases was essentially to decide that there is no such thing as affirmative action legislation. That anytime a statute classifies on the basis of, in both of those instances, race, it's potentially disadvantaging the group that has as its defining characteristic a minority race. And because either it's intended to disadvantage, or because it's intended to help, but to a certain extent may in fact stigmatize. And a majority bought that in those two cases. And what the court said is, then in the interest of, or driven by three motivators: skepticism, that's the skepticism about the beneficial impact of affirmative action legislation; consistency, which is that it's sort of easier and makes sense not to vary the test based on whether we think it's affirmative or benign or not; and congruence between the rules that will apply to the federal and state governments. In furtherance of those three policies, or motivated by those three concerns, the new rule will be that anytime legislation classifies on the basis of race, the level of review will be strict scrutiny, period. That's the rule today. It doesn't mean that you can't pass affirmative action legislation. It just means that if you do, if it's based on race or national origin, then the court's going to invalidate it unless you can prove that it's necessary to a compelling end, which is not easy to do. Now, it has happened, and I want to give you the instances. They aren't very many. The court has upheld affirmative action legislation when the public authority that's defined the classification is making up for its own history of discrimination against that group. So if you have a school district that's historically discriminated in hiring black school teachers, and they pass a rule that has a result of increasing the number of black school teachers in the district, the court has found that to be a compelling end, and depending on what the method for getting there is prepared to find that the method is necessary to the achievement of that end. The other instance where affirmative action legislation has been upheld is in law school admissions. In the case of Grutter versus Bollinger in 2003, the University of Michigan Law School had and has a holistic admissions policy that took account of a number of factors in assessing its applicants, and one of those was race. It wasn't dispositive, but it was a factor that was considered. The policy was challenged. The level of review, because we're talking about race, was strict scrutiny. Michigan Law School, you can do this, but only if it's necessary to a compelling end. So what's the end? And they said, the diversity in higher education. We want a diverse class, diverse economically, socially, ethnically, racially, diverse in gender, and there's compelling educational value in putting our students together with people with all of these different characteristics. And race happens to be one of them. And the court said, we buy that. So diversity in higher education is a compelling end, and the holistic method that the University of Michigan had adopted to get there was considered necessary or sufficiently narrowly tailored to satisfy the first part of strict scrutiny analysis. I should mention that the undergrad admissions program at Michigan also tried to achieve diversity, but their method was deficient. They assigned points for race, and the court said there are other ways to get there. That's not necessary to achieve the end that you're looking for. There is a case now before the court challenging the Texas system of awarding high school places to the top 10% of their high school awarding university places in the state system to top 10% of grads. It's being challenged, and it's to achieve diversity in higher ed, including racial diversity. And that's being challenged now, and the Supreme Court's going to be hearing that in the near future. You should pay attention to that because now you know, right, how the analysis will go. The last thing I want to say it has to do with a certain irony in this result, and it's an irony most famously noted by Justice Stevens in his dissenting opinion in the Adirondack case, and it's an irony that I alluded indirectly to when I began speaking. To the extent that these principles of consistency are meant seriously to apply, what the majority is saying in these affirmative action rulings is if it's race, it's going to be strict scrutiny regardless of whether it's intended to help. So that presumably means if it's gender, it's going to be intermediate scrutiny regardless of whether it's intended to help. And if it's visual acuity or left-handedness or any of the other sort of who cares about it categories, it's going to be rational basis whether or not it was intended to help. What that means, Justice Stevens says, and here's the irony, is that now it's easier to pass affirmative action legislation for left-handed people than it is to pass affirmative action legislation for African Americans. And that's ironic, of course, because it's discrimination against African Americans and a desire to more fully and fairly integrate African Americans into the national political community that generated the Equal Protection Clause in the first place. Thank you.
Freedom 101 is made possible by generous support from Woody Young and the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.